Mediterranean Shipping Company SA and Stolt Tank Containers BV and others.
Yes, Mr. Kenny.
Good morning. My lords, my lady, as you know, I'm Mr. Kenny and I appear for the appellant. Mr. Smith appears for the respondent, leading Mr. Walsh. I have Mr. Hain behind me.
Yes.
My lords, my lady, this, as you've gathered, is an appeal about the construction of Article 2.1 of the 1976 Imitation Convention, and in particular how the court is to apply three provisions of Article 2.1, 2.1e, F and A. What I propose to do in my submissions is look briefly at the convention as a whole and make some general submissions about it, and then deal with each of those provisions, indicating as I deal with each provision which of the component claims we say are limitable under each of those provisions and why we say that. If I can start then with the convention and look at the instrument as a whole, you'll find that in your authorities bundle at tab 7. And though in the course of argument later in the day about insiders and outsiders, we may go to other provisions. For now, I just want to start by looking at Articles 1 and 2. The critical provisions that one has to keep in mind are Article 1.1, ship owners and salvors, as hereinafter defined, may limit their liability in accordance with the rules of this convention for claims set out in Article 2. And then 2, the term ship owner shall mean the owner, charterer, manager, and operator of a seagoing ship. I then take you to Article 2.1, and as you've seen, this is a list of types of claim, those claims defined by what they are made in respect of, and each claims that fall within those types are limitable under the convention. Now, given the importance of the phrase in respect of, may be helpful just to say something about what that means. Our submission is that in respect of can be paraphrased by the English phrases regarding or concerning. It's a phrase which expresses some degree of connection, or in the jargon, nexus. The English term, as the judge recorded in his judgment at paragraph 35, is replaced in the French version of the instrument by the French word pour, which we suggest is translated literally as for, and by Spanish and Russian phrases, both of which can be translated literally as in relation to. The idea of a claim being in respect of a particular kind of loss is an essential building block of analysis you'll have to perform of how Article 2.1 applies, because the conundrum that we all confront in this case is, how do you apply Article 2.1 when a claim could be characterized as being both in respect of one of the kinds of loss identified in 2.1 E or F, and also in respect of damage to the ship? What is the correct approach to characterizing such a claim for the process, for the purposes of applying Article 2.1, when the exercise of characterization can start with two alternative characterizations, one which on the face of things would bring the claim within Article 2.1 and one which would not? And we'll say that the approach that you need to take depends in part, depends as we go through, on the way in which each of the way in which that conundrum arises in relation first to 2.1E, then to 2.1F, and then finally to 2.1A. And I'll expand that.
If I've understood your skeleton correctly, you accept that you, in those circumstances, have to characterize the claim as one or the other.
Can I, for the purposes ultimately of applying the convention, or Article 2.1, I accept that I have to bring the claim within a limb of Article 2.1. As regards 2.1E, our essential submission is it's simply not relevant to the application of 2.1E to ask whether the claim could be characterized as a claim in respect of damage to the ship. The question posed by 2.1E is whether the claim is in respect of discharge or removal of cargo and rendering it harmless, or in this context, decontaminating it. And if the answer to that question is yes, you simply don't need to ask yourself whether the claim could, viewed in its context, also be said to be a claim in respect of damage to the ship. That's not a relevant desideratum for the purposes of 2.1E. As regards 2.1A,
I was looking at, in fact, in your original skeleton, maybe the same as in your replacement one, but at paragraph 42 on page 29, you say that as a matter of principle, the judge was right to hold that a claim that is properly categorised as a claim in respect of the ship is out with Article 2.1, i.e. the whole of 2.1. Have I missed the point of that?
I may have expressed that more clumsily than I'm expressing it to you now. What if in the end, I think the cruder point that I was making there was that if in the end you say this is a claim for damage to the ship, and conclude that it's not within any of the other limbs on that basis, then obviously we fail. But I want to put the point specifically with reference to 2.1E more precisely as I've put it to you this morning. That is, for the purposes of 2.1E, it's simply not relevant to consider whether the claim is to be characterized, or could be characterized, as a claim for damage to the ship, because that's not the test that 2.1e invites you to apply. And I'll come on to this, but essentially, in the context of 2.1d and 2.1e, our submission is it's almost inevitable that any claim which a party might seek to limit under 2.1d or 2.1e has a strong connection to some form of damage to the ship. And 2.1d is all about the ship being shipwrecked. So to suggest that there's no, that the claim is not in respect of or in relation to or concerning damage to the ship, and that excludes it from D, would leave D with no effect at all. So I want to put it more precisely and say in respect of D and E, but relevantly for our purposes E, you have to ask yourself the relevant question, which is this a claim for the removal and rendering harmless of cargo? And it's just not relevant to consider whether the claim is also characterizable for the purposes of 2.1a as a claim in respect of damage to the ship. As regards 2.1f, and I'm sorry, you asked me the question, my lord, as to what the relationship was, and I want, now I've embarked on an answer, may I just...
Well, I asked because I understood you to say, but you've corrected me, that if something was to be characterised as a claim for damage to the ship, then that was an end of it. But you say that's not so in relation to paragraph E, for example.
Yeah. Broadly, but specifically in the context of 2.1e, I put it as I have put it to you. In the context of 2.1f, it's a slightly more nuanced situation. 2.1f is, not for this distinguished panel, but for ordinary readers of this document, one of those documents that makes one want to sit down before you read it. But it is a claim, it is a provision that broadly provides that claims relating to or concerning or in respect of measures taken to avoid or minimize loss which, if it occurred, would be limitable, are claims that are themselves limitable. So it's a parasitic provision. You ask yourself first, would the loss that is being avoided, if it eventuated, be limitable? And then you ask yourself, is this a claim in respect of a measure for the minimization of such a loss?
Well, I suppose there's a prior question, which is what loss is being avoided?
Yes, but I fully accept that. I think I meant to wrap that up into my first stage. The reason, therefore, I say that the question is one which may involve considering whether, for the purposes of the CMA Jakarta 2.1a dichotomy between damage to things that are not the ship, i.e. damage to cargo on board the ship or other property around the ship affected by its operation, what I'll call non-ship damage, and damage to the ship itself, that dichotomy may have an impact on F, is because if the party seeking the benefit of F, in other words, the limitation claimant, in this case MSC, says the reason that your claim is limitable under F is because the damage, if it eventuated, would be damage to cargo or the consequence of damage to cargo. Then as part of that inquiry, you're obviously applying what I'll call the CMA-Jakarta dichotomy between ship damage and non-ship damage. Obviously, if the limitation claimant, MSC in this case, says under F, the loss, if it eventuated, would be extra decontamination charges, which would be limitable under E. Then there's no, the inquiry as to whether this is damage to be characterized as damage to the ship just doesn't arise. So under F, the submission in short is the parasitic quality of the provision may refer you to the ship non-ship dichotomy in CMA-Jakarta if the relevant loss would have been limitable, said it would have been limitable under 21A, or it may not if it said that the relevant loss would have been limitable under some other provision.
Is it an oversimplification to say that 21F is really concerned in broad terms with mitigation of what would otherwise be limitable loss?
That is not an oversimplification, it's a perfect summary. I mean, there is I think some of the difficulty in the language for people who are not absolutely swimming in this stuff is the use of the phrase "the person liable" and the anxious qualification about contracts. So in this case, the person liable for the purposes of F is MSC, in other words, it's the limitation claimant. And the relevant measures must have been taken by someone else, namely, in this case, the owner's Conti. But once you've grasped those simple aspects of it, it is indeed about limitation of claims for mitigation expenses.
And in relation to D and E, can one, sorry, this is really just a thought that's occurring to me, can one get any help from the sort of principle one often applies in domestic construction contexts, where there's a kind of principle that general provisions don't derogate from special ones. So where you have specific provision made, as in D and E, it sort of doesn't encourage one to say at the same time this is also, and indeed properly, to be characterized as just damage to the ship, which is a much sort of broader and more generic type of concept. I suspect this is a red herring, but is any...
We're all friends here. You should just unleash the Latin on us for that domestic principle. The answer is that the concept, our submission is, in line with what you have said, that the concept of damage to the ship is pertinent to the construction of Article 21A, which is concerned with damage, whereas physical damage of various kinds and the consequences of such physical damage. And for the purpose of applying that provision, it's important to distinguish, this court has held in the CMA-Jakarta, between damage which is to be characterized as damage to the ship and damage which is to be characterized as, I've used the label non-ship damage, but stuff on board or around the ship affected by its operation. That distinction is not pertinent to the application of any of the subsequent provisions B, C, D, and E, all of which are concerned with economic losses of various kinds.
Yeah.
And just climbing in on the process of giving simplified summaries of each of those. B is concerned with delay. C is concerned with tort liabilities, but on precisely the principle, my lord, that you've identified, not with liability for damage to property, but other liabilities, tort liabilities of other kinds. D is concerned
That's because of the word other, is it?
Exactly. D is concerned with economic losses resulting from raising, destroying, making harmless a ship which has sunk. And for a point that we're going to come on to, where the judge refers to the travaux, while I've got you looking at D, can you just note that what it says is, including anything that is or has been on board such ship. Right? And that does have a bearing on what the judge subsequently held with respect to the scope of E. And then E claims in respect of removal, destruction, or rendering harmless of the cargo of the ship. And so far as it's relevant, we say removal is a wide term that is apt to embrace both discharge and the moving of cargo from one place to another. So, for example, if containers are have been dropped into a berth, their removal to another place, or any other process of taking cargo away from one place to another. And then,
including by that, you mean transporting them on to their contractual destination?
If necessary, yes.
And the primary focus of removal is surely just on removing it from its location on the ship, isn't it? And then that can be done in various ways. It can be done in the context of normal berthing and unloading, or as part of a salvage operation, or as, well, I mean, the possibilities are endless.
Yes.
But removal means, sorry.
But the simple point that I'm making is simply that the word removal is wider than, but embraces discharge. In answer to your question, Lord Justice Males, you said, does it include sending on to another destination? The only case in which we are aware, the only case of which we are aware in which transshipment costs have been considered for the purposes of the application of Article 2.1 is the Braden Merchant. And in that case, following a casualty, claims were made by the charterers against the owner for transshipment costs, and the judge held that those claims were limitable as cargo damage or the consequences of cargo damage under 21A. So the answer is, it is right to say that transshipment costs could be limitable within the scheme of Article 2.1. I haven't applied detailed thought to the end point of the point at which removal within 2.1e becomes transshipment, which is
well, it may not arise in this case. I don't know, but
no,
if it doesn't, perhaps we don't need to bother too much about it. I can see that transshipment costs of damaged cargo would potentially quite easily come within 2.1a. Not so sure about transshipment costs of sound cargo, if that was needed, but the transshipment costs themselves would seem to come within E, but on-carriage costs seems a bit of a stretch to me.
The question doesn't arise in this case.
Good.
In fact, just to leave you with a sort of uncomfortable sense of complexity, I think the answer is that the relevant cargo that was transshipped in the Braden Merchant was sound, and perhaps the analysis flowed from the judge's conclusion that having been salved and having been subject to a salvos lien, there was an impairment in the value of the cargo.
Yes, possibly.
But that, I mean, that.
All right.
That,
well, if we don't need to go there, then, we've got plenty
needn't
to
be
do.
the major point of my submissions this morning.
All right. Well, we've got quite enough to do.
Okay, that is all that I want to say, or to look at with you, with reference to the terms of the convention. But may I just make a couple of points about the approach to the construction of the convention? Can I make the following points? Limitation is an internationally recognized right afforded to parties who engage in shipping. And there's a useful reference to the international status of shipping, of limitation, in the preamble to the convention, and indeed in the fact of the convention. It serves two purposes. The first is the purpose that was recognized by this court in Lord Justice Longmore's decision in the CMA Jakarta, which you find at tab 15 of the authorities bundle, and the relevant point is the point that he makes at paragraph 11A of that decision, which is the simple point that this is a matter of public policy designed to encourage investment in and the provision of shipping. There is a more sophisticated or another purpose to the Limitation Convention. That is the purpose that was recognised by the High Court of Australia in a decision called Victrol. The facts of the case don't matter, but the relevant passage is in the judgments, and I note that it was a dissenting judgment, but not dissenting on this point, is in tab 18 at page 335 of the authorities bundle, page 468 of the report. And the relevant passage is in the, as the red line indicates, in the first paragraph. And really if you just read from the...
Sorry, which page did you say?
So page 335 of the bundle.
I don't have red lines.
Well, that's a very serious breach of the... I'm just nervously looking to see who signed the front of this. My copy has red lines.
Well, look at you.
All
right, which passage is red lined?
Okay, the red line is against the first paragraph, and the bit that we ask you to read is the sentence that starts, "The purpose of these conventions."
Equitable distribution among claimants.
Exactly.
Yep.
And put shortly, the limitation convention works analogously to an insolvency. It provides a fund against which claimants can bring claims, and that is for the benefit of claimants as well as creditors, as well as debtors, because the claimants are not at risk by tardy action in losing their claim altogether. There is an orderly process of submitting and distribution of a fund. And the judge footnotes at, do you see there's a footnote 6 to Miller, the International Law Association report. And because of the incredible importance of this case, we have gone to the library to get hold of that document. And I will give you a copy, if I may, and ask you to put it into the authorities bundle behind. And in this document, which is the record of speeches given at a conference following the 57 convention and reflecting upon it, Mr. Cyril Miller, Vice President of the International Maritime Committee of the International Law Association, gave a speech in English, fortunately, and the relevant parts to add the missing red lines to are at page 631, where he poses the rhetorical question 3/4 of the way down the page. Was there any justification for perpetuating the principle of limitation of ship owners' liability at all? And then over the page at 632, the answer is at just below halfway down the page, at numbered paragraph number 1, which begins, yes, the principle of limitation should be maintained. And we just invite you to read that first paragraph, which articulates perhaps rather more clearly and simply the point made by Justice Brennan in the passage we've already looked at. Smith is rightly asking me, where does it go into the bundle? And the answer is, I would suggest you put it behind victual. Right. So, my lords, those are the two purposes of the convention. It is axiomatic that the proper approach to construction is as summarised by Lord Justice Longmore in CMA Jakarta at paragraph 10. So that is in tab 15 of the authorities bundle. Paragraph 10, the relevant, he refers to and says it's relevant to consider Articles 31 and 32 of the Vienna Convention on the Law of Treaties and the rules for interpretation there. And then he summarises the approach that the court is to take at the bottom of the left-hand column on 464. It's page 270 of the authorities bundle. Now, that of course says, as you have seen, you are to give effect to the ordinary meaning of the words used, but having regard to context and the purpose of the convention, which is why I've shown you the authorities on the purpose of the convention. And you might then say, well, how does one give effect to the purposes you've identified in the process of construction? And the answer, in a nutshell, is by reading the provisions of the convention broadly and liberally, so as to make the right to limit effective where reasonably possible. And for that closing of the circle, I'll just show you two passages. One is back in Victual. If one looks at page 334 of the authorities bundle, 467 of the report. And in particular, pick up the quote at the bottom of the page, which starts with a comment by the judge. The same view was taken in the United States, where the Supreme Court said in Justin Chambers, and this is the crucial bit, the statutory provision for limitation of liability enacted in the light of maritime law of modern Europe and of legislation in England, has been broadly and liberally construed in order to achieve its purpose, to encourage investments in shipbuilding. So broad and liberal construction. And that statement has its echo in two comments, one by Lord Reed in the Togo Maru, and one by Mr. Justice Thomas in the Aegean Sea. And conveniently, one can find both of those comments together in the report of the Aegean Sea decision. And one finds that at tab 13, at page 230. And under the heading, the approach to construction, I perhaps just invite you to read as far as the heading in column 2 policy. Now, I'm sure you did get them, but obviously the bits that we, in that passage, that we place a special reliance on is Lord Reed saying, just at the bottom of the page, left-hand column, I would therefore apply these provisions to all cases which can reasonably be brought within their language. And then over the page, Mr. Justice Thomas saying that I ought to apply the provisions of the Convention, if possible, to all cases which can reasonably be brought within the language of the Convention.
And that's looking really at the first of the two purposes which you identify. It doesn't say anything about the second.
That is justified by reference to that, but insofar as the first of the two purposes is the more obvious and more discussed justification for an instrument of public policy, the real reason for giving effect to it is because it's an instrument of public policy. Now, you might say, that, rather in the way that Mr. Miller did, this instrument of public policy we now perceive to have some other advantage. But what the law is doing is giving effect to a statute which gives effect to an international treaty, which represents the policy of the nations that adopt it. So the simple answer to your question is yes, he is explaining it in those terms, but you might equally say the reason for reading the Convention in a way that brings all cases which can reasonably be brought within their language, within the language, is because that is the court faithfully giving effect to the policy of Parliament.
Well, I ask because Mr. Smith may say that the second policy pulls in the other direction. See, for example, Justice Thomas's discussion of Articles 9 to 11, and he argues, I think, that the idea of a fund for the benefit of claimants means claimants who are outsiders, in the judge's terminology.
And I mean, the answer is no doubt you are expecting me to say is that presupposes that the fund, that a claim for the cost of putting up the fund is not an unlimitable claim as the judge held. I mean, there's a very simple, the insiders outsiders argument all depends on the submission that an owner who might have a claim against a charterer for the for breach of charter in shipping a dangerous cargo might, in order to defend his position vis-a-vis cargo claimants, put up a fund, put up a limitation fund, and might then find that when he seeks to sue the charterer for shipping dangerous cargo, that the charterer says, oh, I direct you to your own fund. You go and pay yourself out of the monies that you yourself have provided. But the judge said, well, that doesn't happen. And indeed, that doesn't happen in practice, because the owner on that hypothetical brings a claim against the charterer saying, loss item number one, I've had to put up a $10 million fund, and I want to be reimbursed for that cost. And nobody is suggesting, and the judge specifically holds that it is not the case, that the charterer would in that instance be able to say, but your claim against me for the cost of putting up the fund is itself limitable. It's not. So the fundamental answer to all of this is claims between parties who benefit for the fund for the cost of putting up the fund are not limitable funds, not limitable claims. And therefore there's no question of a party having to pay itself out of its own fund. Right. So if I'm right or wrong about that submission, I'll come on to make it in more detail. But if you assume that I'm right to say that the innocent ship owner never has to meet the costs of putting up the fund, because he'll always have a claim against the guilty charterer or whoever it may be for the costs of putting up the fund, then the broad and liberal construction that brings all cases within the ambit of the convention doesn't carry with it the poison pill of inequitable treatment of the innocent ship owner caused to put up a fund. Okay, so in short summary, we've looked at the terms of the convention, and I have made the submission that in giving the convention its ordinary meaning, informed by the purpose of the convention, you should read the provisions of the convention broadly and liberally, and bring all cases that reasonably can be brought within the wording.
Do you, sorry, just a small follow-on point, do you also say that the same principles apply not just to the construction of the convention itself, but also to the characterization of a claim for the purposes of deciding whether it falls within one of the provisions of 1A or not?
I do say that. Whether I say that that proposition is embraced by the proposition that the convention must be read broadly and liberally, or whether it's strictly analytically a separate proposition is a debatable point. I mean, this is the classic.
Yes, that's why I was asking you. But I mean, one sees from Lord Justice Longmore's judgment in CMA Jakarta, and he says this is the kind of everyday exercise that Admiralty lawyers and so on are very familiar with, which I have no doubt is true, but not enormous help to those who don't practice daily in that part of the field.
Frightfully easy for the commercial men, but horribly difficult when you actually sit down to do it.
Yeah.
I mean, the answer is that characterization for the purposes of applying a statutory, or it may be a contractual category, it is the exercise that is classically described as a mixed question of fact and law, where you are simultaneously determining the ambit of the words used in the relevant provision and the nature of the facts to which that provision is being applied. And therefore, my submission in answer to your question would be, it's actually a construction exercise the whole way through, although it may be a construction exercise that's carried on simultaneously with an exercise in fact-finding. it's a mixed question of fact and law.
Yes, thank you.
Right. So I said I'd start with some general comments about the convention and then move on to the specific provisions of the convention with which this appeal is concerned. And I'm going to deal with Articles 2, 1, E, F, and A in that order. So starting with 2.1e, if you have the convention open at page 100 of the authorities bundle, 2.1e covers claims in respect of the removal, destruction, or the rendering harmless of the cargo of the ship. Our case before the judge, and our case today, is that 2.1e applies to and permits limitation of Conti's claims against MSC for the costs of taking the cargo off the ship and the costs of handling it ashore, specifically and in particular the costs of decontaminating it, which we say were the costs of making it harmless. Those costs total about $37 million, and the nature of the relevant costs, the
I mean,
summary
some of the figures we've
costs.
got are given in dollars and some in euros. This is a dollar figure you're giving us, is it?
Let me double check that that's not a fat-fingered typo. It sounds to me, now I look at my note, like it should have been a euro figure, but
Right, okay, we'll check that.
when Mr. Smith nods, that means it should have been a euro figure. If we look at where you find these costs summarized, it's in the judgment at page 44 of the call bundle. And it's paragraphs 12 to 14a. So if you, and indeed this shows you that you, my lord, and Mr. Smith are right to say this should have been a euro figure in my note. Our submission that these costs, as summarized in 12 to 14a at page 44 of the core bundle, are limitable costs for the purposes of applying 2.1e, it is consistent with the only decision on the application of 2.1e, the only reported decision of which we're aware, which is Mr. Justice Thomas's decision in the Aegean Sea, and you find that at tab 13 of the authorities bundle, at page 236. And as you recall, this is a case in which a tanker was wrecked and her cargo and bunkers lost. The effect of the shipwreck was that a very large area of the Spanish coast was affected by pollution, and claims were made against the owners in respect of the losses suffered by all kinds of people, including the local authorities and the operators of businesses in the area. And at 236, starting at the bottom of the left-hand column, the judge is considering, and this is all obiter because he's going to conclude, or he has concluded, that the charterers can't limit against the owner's claims because he wants to qualify the charterer's right to limit as expressed in Article 1.2 to confine the charterer's right to limit to limitation of liabilities incurred in relation to the operation of the ship. And it's that point that's then subsequently reversed by the Court of Appeal in the CMA Jakarta. But having wrongly decided the case on that basis, he then goes on to consider whether any of the claims that are made by the owners against the charterers would have been limitable under Article 2.1. And at this point in the decision, he is considering recourse claims by the owners who've been against whom claims have been made, who then bring a claim over against the charterers. And the relevant part is at the bottom of the second column, where he says the claims for pollution caused by the bunkers and the claims for the pollution caused by the cargo would also fall within Article 1D and E respectively, insofar as they related to cleanup or pollution prevention costs. So that's the extent of the rich case law on the application of Article 2.1e.
So why does he say that in relation to E?
Because that is a claim in respect of making the cargo harmless.
Is it?
Cargo.
Why? It's a claim for damage caused by the pollution when it was harmful.
Well, it in the judge's view, and we accept that this is a strong reading of 2.1e. In the judge's view, that is a claim in respect of, particularly, I mean, you notice he focuses it on cleanup and pollution prevention costs. Okay, so those are costs incurred, therefore claims made in respect of making harmless the cargo of the ship. Okay, so you're right to say it's not a claim in respect of lost business for the seafood restaurants of the bay. It's not a claim for the diminishment in the value of the villa that faces onto the beach. It's confined to cleanup and pollution prevention costs, and therefore within the wording of E, and perhaps I'm reading it too narrowly if I say it's all about rendering harmless the cargo of the ship. It may also be the destruction of the cargo of the ship. Anyway, that is, as we say, the one case in which 2.1e has been applied, and we say that our submission in this case is consistent with that decision, and indeed you might say is a much more obvious case for the application of 2.1e than this would have been. All right, against our submission that 2.1e applies to the costs of discharging and cleaning up the cargo at Wilhelmshaven, there are essentially 4 points. The first is the judge's point that 2.1e does not permit limitation of discharging costs incurred by a party involved in the operation of the ship. i.e. by someone who's a ship owner within Article 1.2. And it's that conclusion, which we'll look at in a second, which we challenged as ground 1 of our appeal, and which we addressed in our skeleton at paragraph 26 and following. The second point against us is the judge's conclusion that 2.1e is inapplicable because Conti's whole claim against MSC is a claim singular in respect of damage to the ship. And again, we'll look at that in a second, what he said on that. But that is the...
Well, that's the one to which you say that's not a pertinent inquiry. That's the submission you've already foreshadowed, isn't it?
That is ground 3 of our appeal. So there's a debate which you may have to resolve about whether the judge ever said the thing we said he said. I mean, Mr. Smith said, Mr. Kenny, I can save you some time. Don't bother with this point because it's not a point against you that the judge made. I mean, you'll look at it. I'm not going to labour it in view of the fact that Mr. Smith says that the judge didn't say this, but our reading of the decision, and in case it's your reading of it too, I'll make some submissions about it, but our reading of the judgment was that what the judge concluded was that the proper method of applying Article 2.1 is not to consider loss by loss or head of loss by head of loss, whether each loss comes within one or more of the limbs of Article 2.1, but rather to make a holistic assessment of the claim and to say this claim in toto is a claim for damage to the ship, which is what the judge concluded it was. And then, having made that conclusion, he went on to say, having concluded that, it's impermissible to look at the component claims, which is what Mr. Kenny is inviting me to do, to look at the component claims and see whether any of those component claims satisfy the requirements of any of the limbs of Article 2.1. And I'll show you the passage that which he either did or didn't say this, but before our eyes were opened by Mr. Smith, denying that the judge had ever said this, the way we put the ground of appeal, which you find in the in tab 2 of the core bundle. Our third ground of appeal, so page 15 of the core bundle, was the judge erred in holding that the appellant's liability to the respondent under an arbitral award was a single claim in respect of damage to the vessel, as opposed to a group of claims, some of which were in respect of damage to the vessel and some of which were not. And that's just a question of, well, first of all, reading the judgment and determining what it is that the judge actually concluded on that point. And then secondly, if you concluded that our impression had been correct, that that's what the judge said, to decide whether the judge is right to embark on an overall assessment of the character of the claim rather than a head-by-head assessment.
But this is the point I was asking you about earlier, and you clarified your position, because this ground of appeal implies, at any rate, that if a claim is in respect of damage to the vessel, then you lose, even if it's only a component of your overall portfolio, whereas I understood you this morning to say that a claim may be in respect of damage to the vessel, but that is irrelevant when you look at E, if it is also a claim which comes within E.
Okay, so, and I entirely accept responsibility for this, but let me just take it in stages. The judge's conclusion, let's just look at it, because although I'm going to deal with this later, we might as well do it by reference to what the judge said. It's paragraph 101 and following of the judgment. And it's a shortly expressed point. He says MSC didn't rely only on Article 21A, so he's brushed off what we've said about 21A. It also relied on 21E and F. In that regard, the technique deployed was to treat Conti as having made a series of claims. So that's a statement about the way in which we analysed the claims made against us. By reference to losses, MS said by MSC to be of different types and to be subject each to scrutiny against the language of Article 21E and or F. I don't regard that as an appropriate technique in the present case. Conti's claim against MSC was that a dangerous cargo had been shipped in breach of charter, resulting in massive damage to the ship. In calculating their award of damages, the arbitrators included the amounts of many items of expenditure incurred by Conti, duly scrutinised by the arbitrators to the extent that points arose on whether those amounts should be included. And there were 3,000 invoices. That means, as will often be the case with damaged ships, that damages have been assessed by reference to actual costs incurred, rather than by reference to either a more abstract assessment of the reasonable cost required to restore an undamaged ship to Conti, or evidence of the ship's pre-casualty and damaged sale values. However, the nature of the exercise in law, and one might put one's pen against that, in law, I mean, does that mean the nature of the exercise for the purposes of presenting the claim in arbitration, or does it mean the nature of the exercise for the purpose of characterising the claim in these proceedings as a claim or claims which may potentially be subject to limitation under Article 2? The nature of the exercise in law was still that of putting a negative value on the damage to the ship inclusive of losses consequential upon that damage, in respect of which Conti made its claim, and awarding that amount as damages. So, and our answer to that is essentially to say, but that's not the right approach to applying the convention. When you apply the convention, you have to consider each head of loss. And if, for example, one of the consequences of our shipping dangerous cargo on board your ship was that the owners incurred 30 million euros of expenses decontaminating containers in Wilhelmshaven, we are permitted to say you have made a claim in respect of decontaminating the costs of containers in Wilhelmshaven, and that comes within rendering the cargo harmless for the purpose of 2(1)(e). And I don't have to look at the overall quality of the claim and say, you know, here's a Quality Street box. You know, there are toffees and there are strawberry chocolates, and say, but overall I think it's a toffee. You just do it by reference to the component claims. And I mean, it's perhaps not necessary, having made that submission, to comment on the artificiality of the assumption that the judge is making about the process of claiming in the arbitration. I mean, we know what, and you can see what the claim in the arbitration was. You've got at tab 17 of the core bundle, and this is a real test for judicial eyesight. Anyone's allowed to pull out an enormous magnifying glass for this, but you have the invoices, and to suggest, which is essentially what the judge is saying, that all of these claims, which were presented and claimed as the serial consequences of shipping dangerous cargo, were just a proxy for them saying, at the moment of the explosion, our ship had gone from being worth $30 million to being worth minus $170 million. Because that's what it is. I mean, the ship it was worth 30 million or 50 million, whatever figure you like, but the award is 200 million. So what he's postulating is that the claim could have been pleaded as a claim that the explosion had the effect of turning an asset of plus $30 million into into a what? A sort of a bundle of liabilities, the net value of which was, say, minus $170 million. We're familiar in commercial damages with changes in value being used as a proxy for the impact over time of a breach. Right? That's a familiar technique of assessment of damages. You supply me with soybeans, which are off spec. I then have difficulties with my suppliers. I have to treat them. You know, there's a whole series, and I might put my claim on the basis that it is a series of consequential losses, a series of consequent losses over time constitutes my loss, or familiarly, whether I sold or not, one has the Sale of Goods Act proxy for my loss, which is to say, well, if the goods had been on spec, they would have been worth $50 a ton, and in fact they were worth $40 a ton. That's a, but to suggest that in this arbitration, where there were thousands of invoices representing outlays which were incurred over years. I mean, this is a period of 2 or more years during which all these was just a sort of a proxy, and that in law, the change in value was the fundamental nature of the loss. So that the loss suffered by the ship owners was the devaluation of their asset from plus 30 to minus 170. Is, in our submission, a very artificial characterization of the nature of the claim. But that's a lot of deprecation of the judge that I don't have to go in for, because my primary submission on this point is just to say that the exercise which the convention requires is to determine whether any specific individual claim in respect of a specific or individual loss is a claim which comes within one of the subparagraphs of Article 2.1.
So you would say, looking at that long schedule in tab 17, that you would go through each one and
Yes,
ask yourself the question.
In fact, the schedule resolves itself into about 8 heads of loss, each one of which may have hundreds of invoices under, but all those invoices are for the purposes of applying Article 2.1 materially identical. So although there's an invoice for January wharfage and for December wharfage, there are dozens of invoices for cleaning containers.
Okay, but each of your heads of loss is things like that, damages to
Exactly. So we have just taking the 2.1e case, we have identified 37 million euros worth of invoices, all of which we categorized in our particulars in these proceedings as being costs of discharging, cleaning, handling ashore cargo. And the owners accepted that that categorization was correct, subject to the points recorded in the judge's judgment where they had second thoughts about some of them. So if I can just take you back, my lady, to paragraph 14 of the judgment. And I'm sure you have picked this up, but the numbering of the judgment is slightly deceiving because
Yes.
it goes through to 21, and then the paragraphs from there on are the paragraphs of an agreed statement of facts, which the trial was, on the basis of which trial was conducted. And we said all of these heads of loss together constitute discharging costs for the purpose of 2.1e, and the judge then adds, but then MSC, by an amendment in June 2022, argued that 47 of those invoices were not invoices for cargo handling. And then by re-amendment, a large number of other items were also. So there's actually a tribal issue still about some of these items, but there is still a large set of invoices which constitute a head of loss, and that head of loss, we say, is the costs of discharging, cleaning and handling ashore the cargo. And all of the items within that head of loss, we say, come within 21E. And you could do it by looking at it invoice by invoice,
Yes,
or in fact the parties just
But
agree.
in summary, you're looking at the end point, the loss incurred, and you're characterising the claim, if you like, for Article 2 purposes by reference to that particular loss,
Exactly.
type of loss.
Exactly.
Whereas the judge was or may have been saying, well, the reason you're making this claim is because there's been damage to the ship, and the heads of loss are not the or the types of financial loss are not the focus. He said.
Exactly.
Okay.
Exactly. He said that, and again, I said you might pause at in law. He said that whether this was a feature of the claim made in the arbitration, or whether it's a feature of the application of the convention, a point that arises at the stage that you apply the convention, at law, the owner's, Conti's claim, was a claim for damage to the vessel, singular. And it appears that that may be a view that was taken on the basis that the individual outlays over 2 years, some of which were to do with repairing the ship, but all sorts of other things, were a proxy for, or were just another way of expressing a loss that, inverted commas, in law, was the transformation of an asset into a net liability. I think he had in mind, may have had in mind, the idea that if you'd said to the owners on the day after the casualty, how much do you, how much will you pay me to take this off your hands? There could have been a price for that. But whether that's realistic, whether there is ever a market for a distressed asset like a flaming ship, is a question. But it's another question whether in law that's the right way to view a claim which has been presented as a series of heads of loss suffered over time.
But, I mean, what the judge may have been thinking of is if you think in English law about a distinction between liability and quantum, liability for damaging the ship, then you could characterise potentially all of these outlays as relevant to quantum. I think you're saying the word claim in Article 2 is not used in the sense of the liability element. You look at the individual quantum elements.
But Mele, you're absolutely right when you say one familiarly distinguishes between liability and quantum. But what was the liability here, and what had to be proven in order to establish liability? The liability was breach of charter for shipping non-permissible cargoes and undertaking to indemnify against the consequences of having shipped dangerous cargoes. And because this was a contract claim, establishing that there had been any loss at all was not a necessary component of proving liability. This isn't a tort claim where they had to prove that there was damage as a component or an ingredient of establishing liability. This was a contract claim, and they only had to prove, and the dispute was about whether there had been a breach of the relevant clauses controlling what we were putting on board the ship. And after that, all the consequences of the cargo having exploded and all the outlays was all part of quantum. The existence of loss, as well as the quantification of the loss, was an aspect of quantum. May I, because you have got the schedule, which is also give you what you haven't got, which is the particulars of claim in the arbitration. And I don't know at this stage whether you're going to say that the judge did do the thing that we say that he did, and if you think that he did do that, whether it's then relevant for you to consider how the claim was put in the arbitration. But in case it's relevant to do that, let me just give you the document.
I must say I read paragraph 102, which is in the past tense, as describing what the claim, or how the claim in the arbitration ought strictly to be viewed. And it looks as if the judge is saying that a claim for damage to the ship has, in law, to be seen as a claim for diminution in value. I might have put that. He might have meant something else, or he might not. But it looks to me as if it's what he's saying.
Well then, on that view, it may depend on what overriding effect you give to how the law treats a claim for breach of the obligations not to ship dangerous cargoes. Summary. I mean, I'm slightly simplifying that because, as you'll see, if you look at the claim, the breach alleged was both a breach of certain restrictions as to, so in this document, a kind of commendably short and simple pleading that one expects in a well-pleaded commercial case, the terms are pleaded at. The relevant terms are terms that control the shipment of dangerous cargoes. It's then pleaded that there was an explosion on board that takes you through, and then at 22, by reason of, so that's page 8 of 14.
Where's the plea of breach? There's the aforementioned breaches. I was just looking to see where they were.
That's 13.
Ah, yes. Thank you.
Owners have suffered loss or damage, and then the way in which the loss is articulated is she was severely damaged in the incident, and she was repaired at a cost of 29 million, and a breakdown of the sums paid to the repairs is provided. And then the owners also incurred an LOF liability to salvors. There were various liabilities and potential liabilities to government bodies. There were berth dues and port and cargo handling charges during the recovery of and repair to the vessel. Various costs in respect of handling of the water used to extinguish the fire. various disbursements and other fees related to the repairs, various disbursements and other fees related to the casualty, and so on.
The cargo charges that we're talking about at the moment, is it clear where they fall in? Are they in 22.4?
They embrace more than one paragraph of this.
22.7, for example.
Yes. No, that's not within 21E. That is a loss that we claim under 21A only now.
And all this shows us is how the claim was pleaded as a matter of English law under a charter party governed, I imagine, by English law.
Yes.
But we're dealing here with an international convention which has to apply to every type of jurisdiction across the world, whether it has a common law system, civilian system, or whatever. So, I mean, that should encourage us, shouldn't it, to look at the language of little e through that lens. And what we're looking for is simply a claim, which must obviously have some legal foundation in one way or another, in respect of, and then we could hardly have simpler language, removal, destruction, or rendering harmless of the cargo. And doesn't that encourage one to look at the, at the nexus between the claim that's being made and the cargo on the ship? And if the answer is yes, that was the basis on which money is being sought by way of a remedy, well, there you are. Or if not, what's wrong with that? Why is that too simple an approach?
And nothing is wrong with that. What the convention requires you to look at is whether a demand for a remedy, a claim, has been made in respect of, having a connection with, concerning losses of the relevant types, i.e. removing the cargo from the ship, making it harmless. You are right to say that it cannot affect the application of that provision of an international convention, that as a matter of the English law of charter parties, or the English law pleading of a claim for breach of charter party, the claim made in that English law arbitration is to be, or could be described as, a claim singular for damage to the ship. And so, yes, I encourage you, were you to do make the submission, were you to perceive that that was how the claim ought to be characterized for the purposes of an English law charter party claim, nevertheless, the head-by-head approach is what is mandated by the terms of the International Convention. However, my submission with respect to the juridical character of the claim made in the arbitration is that it was not in any sense a claim singular for damage to the vessel. It was a claim which included various heads of loss, which related to damage to the vessel, but it was put forward not as a single claim for damage to the vessel, but rather as a claim for all of the consequent losses and expenses that flowed from the shipment of dangerous cargo.
Well, it's a claim for breach of contract. I mean, that's a,
Yeah.
what is at the most simple, basic level.
Strictly, it's a claim for breach of contract, but also a claim for payment under an indemnity, and it's just a curiosity of the way in which the Hague rules were drafted, that the remedy for which the rules give an owner where a charterer puts dangerous cargo on board is not damages for doing something which he shouldn't have done, but an indemnity against the consequences. And that this really is by lane of this, but it just to be strictly, to be precise about the way in which the claim was put, it was put on two footings. One for breach of a clause called Clause 78, which was restricted the circumstance in which dangerous cargo could be shipped, and secondly for an indemnity under Article 4 of the Hague Rules, and at a certain point in the arbitration, that made a difference to what the measure of recovery was. But
sorry, just to clarify, the only reason why the indemnity can be claimed, presumably, is because there has been a breach of contract.
Or it's just a promise that the charterer will indemnify the owner against any consequences flowing from his having put dangerous cargo on board.
Yes, in breach of his contract. Oh, but you say not necessarily.
Not necessarily.
Okay, I see.
My lady, in effect, it doesn't make very much difference. In fact, the only consequence of it being formulated as an indemnity is that the remoteness rules that apply are more generous to the owner.
Yes, and it may partly explain the negative value point. You've got a 200 million claim. It's easier to.
In our submission, not.
Right.
I mean, you have both a contractual undertaking not to ship dangerous cargo and a promise to indemnify against the consequences if you do, and on either and both bases, they recovered what they pleaded, which was costs of repair, costs of handling the cargo, costs of paying the salvage, a series of claims. And nobody at the time of the arbitration sought to express that as a singular global loss in terms of the depreciation of an asset. And my submission as a matter of English law in response to Lord Justice Mayall's saying, well, might it be the case that in the arbitration the claim was to be regarded as a claim for damage? The answer is that is not in our submission reflective of any principle of English law.
Can I just see if I can summarise in my own words what I think you're saying and see if I've understood correctly?
Yes.
Which is really that there are three stages. Number one, it was not in fact claimed as a singular claim for damage to the vessel. See the pleading in the arbitration. Number two, I think you say that there is no reason why it had to be so characterised in English law, and if the judge was saying that it did, then he was wrong about that. And number three, even if it does have to be characterised in that way in English law, that doesn't affect the application of an international convention, where you just ask if it falls within the language of paragraph E.
Precisely.
Yeah, okay. Thank you very much.
Okay, so the discussion we've just had was an illuminating excursion because I was summarising the points that I was going to address under 2.1e and the arguments that stood against my submission. And I'd actually got as far as saying the second point against me is this point about the holistic point. And in the end, we've been sort of drawn almost into arguing. So I won't have as much to say on that when we get there. I think I'll
Just before you tell us what number 3 is, you took us to the agreed facts, and that reminded me to ask. There was reference there to a decision in the, can't find it now, awaiting judgment from an American court hearing in 2020, which had not materialised by the time of the judge's judgment.
So,
are we any wiser now?
Yeah, we are. The appeal was heard by the US Appeal Court, I forget now, Second Circuit, in May 2020, in the high days of COVID, and we all listened in to, by equivalent of live stream, and then the appeal court took until last week to hand down their judgment. And
well, that gives us a target.
Whether they were in any way influenced by knowing that this case was coming before you and the sort of intakes of breath that might be if they hadn't handed down their judgment, in any event they got it out before. And the position now is that District Judge Forrest's judgment on liability is upheld. So on appeal, it remains the case that Stolt and Deltec are liable both to Conti for Conti's losses and to us to indemnify us against our losses, which will include any liability that we have to Conti.
Right.
And the position in the US litigation, therefore, is that the claim, which is a multi-hander involving us, Conti, and then Deltec, who were the manufacturers of the product, Stolt, who were the freight forwarders who arranged its transport, is that between those parties and certain other parties, there will be a liability, a quantum hearing, which will take place at some stage in the future.
Right. So, for limitation purposes, though, there will be no further claimants against the fund.
There,
because Stolt won't have a...
There are claims by Stolt, which in theory they could bring forward, but you're right, in practice they won't, because they're liable to indemnify us for any such liabilities. Stolt have taken assignments of various cargo claims from the original bill of lading holders.
I see.
They could pursue those claims, but in practice they won't do so.
They'll only come back on themselves.
Because it'll only...
Well, for completeness, perhaps we could have a copy of that judgment.
Yes, we'll provide that.
Thank you very much. All right, anyway, you're going to go on to point 3.
Do you want it electronically or on paper?
That doesn't matter.
Okay. All right, so I said I'd got as far
Actually,
as...
if it's long, I think I'd rather have it on paper, and then I won't have to print it out. Okay. On second thoughts.
All right, I had said that there were 4 points against us. The second of which we discussed in some detail, which was the judge's view that Conti's claim was a claim singular in respect of damage to the ship. The third is that 2.1e is inapplicable because even when Conti's claims in respect of the relevant heads of loss, i.e. discharging costs, decontamination costs, are considered as separate or individual claims, those claims are still properly characterized as non-limitable claims in respect of damage to the ship. And that is the argument that Conti advanced in paragraph 60 of their skeleton argument. And it's in response to that argument that I make the point that I made this morning about 21E not requiring the court to consider whether it's damage to the cargo. Right, so, my lord, when you said to me,
not cargo.
Sorry,
Not
damage to the ship. Apologies. Yes, ship.
Yes.
So, well, when you said to me, well, that point you made this morning, I was making that point about 21E and what the court needs to ask itself in relation to Conti's argument that the claims for discharge expenses are properly characterized as claims for damage to the ship, even taken in isolation, not looking globally at the whole thing, but just looking at those claims. They say those claims, even though they're for wharfage and spraying the containers, they're still claims for damage to the ship on their proper characterization. Right, so
Is that connected with the fact that they were done as part of the process of preparing the ship?
That submission, Mr. Smith will put it much more elegantly than this, but that submission is founded on two propositions. One is that the genesis of all these expenses was damage to the ship. In other words, the reason why the ship was being discharged was because the ship was damaged. And the other is that the telos of all these expenses was damage or repair to the ship. In other words, the reason why, in fact, these owners were wanting to put all these containers onto the quayside and hand them over to their owners was because they wanted to get on with repairing the ship. So it's a first cause prima causa argument and a objective argument, two ends of the bookcase, and they say, well, whichever end you look at, this is damage to the ship. And we say, well, you don't look at the two ends, you look at the thing in front of you, which is what the actual process was, which was discharging the ship and cleaning the containers.
So you mean discharging the cargo again?
Yeah, I'm getting tired. I'm so used to practicing in arbitration, by which time, we're well past coffee break. Yes. The answer is their argument is genesis and telos. This is damage to the ship, and we say don't worry about either what the original cause of this was or what it was directed to as by way of an ultimate objective. What matters is what they were actually doing.
They have a lot more Latin and Greek in arbitrations, do they, Mr. Kenny?
An LMA arbitrator won't let you go through a page of a notes without a couple of Greek quotations. All right, and then final point, 21E, fourth and last point, 21E is inapplicable because no claim can be made by one ship owner against another ship owner except by way of recourse in relation to claims initially made by a non-ship owner. And this is the insider-outsider argument, which is the subject of Conti's skeleton paragraphs 57 and 59 is where they apply it to specifically to the claim under 2.1e, but it builds on the argument that they open their skeleton with at paragraph 14 and following. Okay, so I'll take each of those 4 points in turn. So point 1, does 21E allow limitation of claims in respect of cargo discharging carried out by a person involved in the operation of the ship? And it's worth just identifying precisely where the judge expresses his conclusions on this subject. The first critical paragraph is paragraph 125 of the judgment, which you find at 76 of the So the judge says, whether simply on its own terms or when read alongside Article 21D, in my view, Article 21E does not have in mind at all the discharge or post-discharge handling of cargo by or on behalf of the ship. And then he elaborates that by saying, whether acting through her own crew and equipment or by shore labour, whether arranged by the owner itself or by a charterer, or therefore claims as between an owner and charterer regarding responsibility and say for the cost of such cargo operations. And then he expands that in 126 by saying the ordinary meaning of Article 2.1D/E is that tonnage limitation is to apply in respect of liabilities such as might be incurred by an owner for casualty intervention or aftermath liabilities of the kinds indicated, i.e. wreck removal 21D and cargo removal, destruction and neutralization 21E. And then he restates that conclusion in slightly different language at 164 Roman 1 when he's summarizing his response to our reliance on 2.1E. And this is where the language of not involved in the operation of the ship comes. He says, so this is page 85 of the bundle. Conti's claim in respect to cargo handling costs at Wilhelmshaven would not be within 2.1E, because 2.1E concerns only claims by a party not involved in the operation of the ship for having had to deal with the cargo that needed to be removed, destroyed, or rendered harmless, and doesn't cover a claim between an owner and a time charter in respect to the cost of cargo handling undertaken pursuant to the charter.
That seems to bring together your first and your fourth point, or the first and fourth point that you've identified as being against you.
It's the first point.
Well, it also makes the one ship owner against another point.
It carries a whiff of the fourth point, but the fourth point is a different point, which the judge has expressly rejected in the first passage we looked at.
Where he says his point is not inconsistent with his rejection of Smith's overarching point.
Exactly. So, so the judge, the insider-outsider point is Mr. Smith's respondent's notice point. The judge rejected the insider-outsider argument, but he said, not, even though I reject that, I find on the construction, narrowly on the, so the insider-outsider point is a point about how Articles 1 and 2 operate and what kinds of claim are covered by Articles 1 and 2. it's a high-level point, and indeed one of the points we make against it is to say, well, where do you find that in the wording? I mean, it's so high-level, it's just not articulated anywhere in Articles 1 and 2, but we say. But the judge rejects all of that. He then says, nevertheless, just focusing narrowly on the terms of 2.1e, I find that 2.1e should be read as if it said, just open up to an E, claims in respect to the removal, destruction, or the rendering harmless of the cargo of the ship by someone other than a person involved in the operation of the ship.
So you don't read those words into Article 2.1 as a whole, he says, the overarching point.
Into 2.1e.
But you do into 2.1e. Is that
Exactly.
what he's saying?
Exactly. He says the kind of claim that the words claims in respect of removal, destruction, or the rendering harmless of the cargo is envisaging is a claim by someone other than a person involved in the operation of the ship. And our first and central submission about that is that reading does not reflect the ordinary meaning of the words used. It is, in the language used by Lord Justice Longmore in the CMA Jakarta, a gloss.
I take your point about the ordinary meaning. To what extent do you draw support from the purposes that you identified earlier in your submissions? The two purposes you identified.
The two purposes flow together to inform your reading of the instrument, and they inform it by steering you to read these provisions broadly and liberally so as to give effect to the right to limit. And if you were to find that an owner could not limit against a charterer for expensive costs of removing cargo, or a charterer couldn't limit against an owner, because these things go two ways, you are making a major inroad on each person's, each party's right to limit. That is a very significant curtailment of what is otherwise an effective right to say, out of this maritime adventure, I may be exposed to liability, as a result of this maritime adventure, I may be exposed to liability, but it will be no more than this amount.
The reason I ask is the second of the two purposes you focus on, which is the equitable distribution among claimants, perhaps doesn't apply to the same extent in this sort of context.
Charterers and other persons involved in the operation of a ship, in the sense of are playing some contractual part, form a potentially large class and potentially a class of persons, and a class of persons with rather uncertain boundaries. So an owner may time charter his ship and the ship may then be sub-time chartered.
Yeah.
The sub-time charterer may voyage charter the ship. The voyage charterer may slot charter to, and what you have is a class of persons. And then when you look at Article 1.2, the other people involved are the owner, the charterer, the manager, and the operator. But that's just 1.2. I mean, for the judge's description, persons involved, would he include a bill of lading holder who had contracted to discharge the ship? It's not unusual that someone who's not within, and one of the points we make is that it would be simplistic to assume that any of the large number of people who might be ship owners within Article 1.2 wouldn't have just as strong an interest in participating equitably in making claims against a fund as people who are not interested. Right, so point one, it's a gloss. Point two, rather anticipated by my answer to my lady's question, is that it's a gloss of uncertain ambit, to adopt the phrase used by Lord Justice Longmore in the CMA Jakarta. And it's enough to demonstrate that to consider any one of a number of examples of the potential difficulties involved in applying the implied qualification that the judge has formulated. Right. It's not a good start that the judge formulates it in one way in 125, paragraph 125, it says, for and on behalf of the ship. And then at 164, for and on behalf of anyone involved in the operation of the ship. And I mean, you might say, well, that's broadly the same thing, but it's not necessarily the same thing. And this is effectively words that you are being asked to imply into a statute. And it's easy enough to multiply examples, but how do you apply the judge's implication when discharge is carried out or removal is carried out by a public authority, but purportedly on behalf of the owner? It's not an altogether unusual situation that under a relevant statute, the authority has power to act on behalf of the owner. Or what about the converse case? The owner actually does the work, but on the orders and instructions of the local authority. Or what about the case contemplated by, sorry, I keep referring to the CMA Jakarta, but it might just be helpful just to turn it up. In para 15, sorry, tab 15, at page 271, you have the two needles of Lord Justice Longmore's critique of Mr. Justice Steele's judgment at 15, where he says, it's imposing a gloss on the wording of the convention and according to a meaning other than its ordinary meaning. It also imposes a requirement of uncertain ambit. And then there's quite an instructive passage in 14 where he talks about the difficulties of determining whether a charterer is acting qua owner in relation to discharge operations because of the uncertainties as to who engages, pays for, and is responsible for the actions of stevedores. So following that approach to the implication into the convention of qualifications, I give you a series of examples, and obviously I've given you the first one about the authority acting in proportion on behalf of the owner, and the owner acting on instructions of the harbour authority. But a third one might be the stevedores who are engaged to discharge on the order of the authority, but for the account of the owner. And then finally, an example I've already mentioned, what about the case where it's the bill of lading holder who's not, for the purposes of Article 1.2, a ship owner, and in that sense involved in the operation of the ship, but it's the bill of lading holder who, either under a contract with the charterer or under a contract with the owner, depending whether it's a charterer's bill or an owner's bill, does the discharging. Is that within or without the judge's implied qualification? So, two points against the judge's implied implication. One, it's a gloss, and two, it's a gloss of uncertain ambit. We then say the judge is also making a mistaken inference from the terms of the text, or the terms of Article 2.1d. Let's just remind ourselves what he says on that subject at paragraph 126. Sorry, 126, page 76. He says that tonnage limitation is to apply in respect of liabilities such as might be incurred by an owner for casualty intervention or aftermath liabilities of the kinds indicated, i.e. wreck removal, Article 2.1d, and cargo removal, destruction, neutralization. Now, insofar as he says these are aimed at the kind of liabilities that might arise from a casualty, that may be true, but you don't draw from that that they are intended to be confined in their application to resultant claims by third parties, however precisely you define the term third parties. He then says, I'm supported in this view, this is paragraph 127, by the Travo, which take D and E together. And we accept that's a fair point, they do take D and E together. But it then says, they record their purpose, namely in this way. Subparagraphs D and E are necessary in addition to previous subparagraphs in order to make claims for wreck removal and removal of cargo subject to limitation. But that's just question begging. I mean, it says it covers cargo removal. It doesn't, by the language of that provision, in any way circumscribe what kinds of cargo removal you're talking about. And then he says, and this is where at last, with relief, we can get into the Travo, because that's where all great answers to be found. It's clear that subparagraphs D and E were only kept as separate provisions, a proposal having been made one of the preparatory sessions that they might be a single paragraph. To be clear that tonnage limitations in situations of or akin to shipwreck was not confined to claims by those who dealt with the cargo still on board a wrecked, stranded or abandoned ship, but also to those who dealt with cargo that had been jettisoned or otherwise detached from the ship. Now, our submission about that is just reading far too much into what the travaux actually say. And just to understand how the judge is adding 2 and 2 and arriving at an answer of 5, you need to look at the relevant passage in the travaux, which you find in the authorities bundle at tab 23, page 980.
Is that going to be volume 2 or 3?
Very nice. It's going to be volume 3. When I say 980, that's 980 in the original, in the blue script. So volume 3, blue script, 980.
Yes.
You know, the bit that the judge has focused on is paragraph 28 at the bottom of the page, which is a record of the 25th session of the IMCA Legal Commission. He says, it says there, a suggestion was made that 1D and 1E might be one subparagraph, but the committee accepted the view that the 2 subparagraphs were concerned with factual situations that might be distinct. So far, so consistent with what we say. E.g., the cargo might be jettisoned or otherwise detached from the ship. That's an example. It's not i.e. It's not supposed to be an exhaustive statement of the circumstances in which E would apply because D did not apply. It's just an example of one case that might be covered by one provision, not the other. And the lack of centrality, or the unimportance of that observation, is confirmed when you look at the text of the provisions as they were being discussed at the 25th session, which you find at the top of the page. And what is critical about the text at the top of the page is that it doesn't have the wording that I asked you to focus on, particularly this morning when we looked at 1D. Remember I said, look at 1D and it says, anything that is on or has been on the ship. Right? At this point, when they're discussing the example that the judge feels confirms his view of the scope of E, and he makes regards as important and revealing that there's, for example, the cargo might be jettisoned. That example only falls within E because at the time, the draft of D, unlike the final version of D, didn't deal with cargo that's been jettisoned during a shipwreck. Whereas the new version of D, the D that actually made it into the convention, does deal with cargo that's been jettisoned from a shipwreck. may feel that all of this is terrific obscurantism and of limited assistance with construing the terms, the plain terms of the convention. If you say that, we agree. But we simply make the point that the judge's reliance on this passage as indicating that words of the kind that he has implied into E should be implied is far from the kind of bullseye illumination that would justify the use of the travo in the way that he has. Putting that more clearly, the travo do not clearly support the conclusion that the judge draws from them. Okay, so
nor do they appear to explain the origin of the words that is or has been on board. Do they? Just from glancing through, I can't see it.
The is or have been is introduced at a later stage of the drafting. I can't tell you now whether there is, and I think the answer is that there is nothing else in the travo that refers to the introduction of those words.
No, I was just glancing through the next couple of pages till we get to the text of the convention on page 983, and on a quick read I can't see anything, but maybe it doesn't matter anyway.
On one view, those words render E unnecessary.
If the judge were right, judge were right about the scope of E. I mean, insofar as the judge is saying, well, the reason we have E is to cope with jettison cargo from shipwrecks, in the light of the final drafted version of D, we wouldn't bother to have E at all. But the reason that is one finds oneself in that position is because the judge has set off on the wrong foot. E is to be given its natural scope. It deals with discharge and cleanup operations, and D deals with shipwrecks. I mean, D is an exhaustive treatment of the consequences, claims relating to shipwrecks and their cargo. And E is a treatment of the it provides for the limitability of claims relating to discharge, removing, cleaning cargo. And of course there may be some overlap between these, and we've seen examples, for example, in the Braden Merchant we looked at, where a single claim might come within two limbs.
Yeah.
But it's quite clear in our submission that E has a sphere of operation which has nothing to do with the shipwrecks that are the subject of D.
So you say that once the casualty has happened, then somebody has got to bear the cost of rendering the cargo harmless, which is one of the things which E is about. And you say there's nothing in the language to exclude the case where an insider incurs that cost, and that from the point of view of giving effect to the convention purposes, it shouldn't matter whether those costs are incurred in the first instance by an insider or an outsider. If they're incurred by an insider and that insider has a claim, then it's limitable.
It is perfectly, it is within the I agree and adopt everything you've just said.
Well, I was trying to just summarise.
I appreciate it. No, I mean, I endorse it as a succinct summary of what I've said. But we say with respect to arming you to give the language of 2.1e its ordinary meaning, we say that there is nothing contrary to commercial expectations, that the costs of cleaning up or removing cargo from a ship would be borne by either an owner or a charterer or someone else involved in the operation of the ship. That is routinely the case. And that being so, nobody would be surprised about the creditors of the party who finds himself doing that seeking to limit their liability. Okay, so it's a gloss. It's a gloss of uncertain ambit. There is no assistance to be drawn from either the terms of D&E or the Travo. I will say again, but say only in a sentence. You should read E in a broad way and not, as the judge is doing, in a way apt to limit its effect. And then I make two final submissions in response to the judge's analysis. The first is that the judge perhaps implies, rather than saying in terms, that the allocation of the costs of discharging by either the charterer or the owner following a casualty is the subject matter of the terms of the charter between them. And I say implies rather than says in terms. I particularly have in mind the way in which he expresses his conclusion in paragraph 135 of his judgment. He says a claim between an owner and a time charter for reimbursement during the course of a time charter incurred by one of them, but said to have been the responsibility of the other, pursuant to, by reason of a breach of the time charter, is not a claim in respect to the removal, destruction, or rendering harmless of the cargo. And although he doesn't say, well, it's because there's a contract between them that it's not within E, the very insistent focus on there being an owner and a time charterer and reimbursement of a service performed between them during the time charter, although one of them said it was the responsibility of the other under the time charter. You see the way the judge's mind is focusing on the time charter, and he's drawing an antithesis between the relationship governed by the time charter and the relationship governed by the convention. He's saying, well, because this is governed, he's implying at least, that because of the existence of the time charter, that is grounds for assuming that the draftsman of the convention couldn't have intended the convention limitation right to apply. And insofar as that thought was influencing the judge or might influence you, I simply remind you of what the judge himself said about the relationship between tonnage limitation as an element, a plank of public policy, and parties' contracts. And I'd just take you, if I might, to paragraph 96 Roman 1 of the judge's decision at page 70 of the bundle. I might summarize this just by saying this is the judge ticking off Mr. Justice Thomas for doing the very thing, for falling into the very heffalump trap that he then falls into himself. I'll let you read that. So, in short summary, one needs to put aside the assumption that because a matter is regulated by contract, that is a justification for not applying the convention in accordance with its terms, because you'd expect a matter to be governed by contract. Tonnage limitation applies after the contract has, and any limitation for which it provides, has been applied. And in this case, the fact that there is a claim against us for the costs that the owners have incurred in discharging and cleaning the cargo is because of a charter between us, under which they've obtained an award for 200 million, and our right, our statutory right to limit, applies only at that point, i.e. at the point that our rights inter se, the rights between the parties, have been determined as a matter of contract law.
Well, a claim by an outsider may be regulated by contract. The typical bill of lading cargo holders, bill of lading holders cargo claim will be.
Precisely in the context of, and precisely in the context of 21E, I mean, of course, the paradigm case that the judge has in mind is a claim by the Wilhelmshaven Harbour Board for craning off the dangerous cargo and hosing it down on the quayside. But in reality, between that paradigm case and the case of a claim for recovery of costs between time charterer and time chartered owner, there are a million gradations of grey, which may involve at every stage people acting under contract or not.
I mean, it's plainly contemplated by the convention that there may be a contractual relationship. I mean, one only needs to look at Article 2.2, the last line. Claims set out under 1D, E and F shall not be subject to limitation of liability to the extent they relate to remuneration under a contract of the person liable.
Exactly.
And it's implicit in the concept of a claim, that it may be a contractually based claim.
I don't want to unjustly criticise the judge for stating a proposition in 126 that he didn't actually state, that because there's a time charter. I just draw that to your attention because it does appear from the way paragraph 126 is expressed that looming large in the judge's conception of the scope of 21E was an antithesis between the paradigm case of the Port Authority swooping in, no contract, and the paradigm contrary case of a claim between time chartered owner and time charterer.
Sorry, do you mean 126 or do you mean 135?
I mean 135. Apologies.
Right.
Okay, so that's everything I wanted to say about the judge's implication. I have still on 2.1e, briefly to come back to his "it's all one claim" point, but I think we've largely covered that. And then I have Conti's 2 points: a claim for discharge expenses is to be characterised as a claim for damage to the ship. And then finally, the insiders-outsiders. That's all 2.1e. I then have 2.1f and 2.1a, but each of those gets shorter because the same points are taken in respect of each one. So I anticipate, well, certainly easily finishing within today, but I hope before 4 o'clock chimes.
Very good. All right, we'll adjourn till 2 o'clock.
All right.